on there, please feel free to email me any questions as well. Okay. And now I see that we're officially recording, so I'm going to start. My name is Kate Leeson. I'm one of the attorneys here at Altitude Community Law, and I handle pretty much only foreclosures at this point. So here's our housekeeping, and I'm just going to go ahead and read this to you all. It says, on your screen, you'll see the PowerPoint presentation in the center of your screen. This should take up most of your screen. There should also be a small box on the right-hand side of the screen with the video feed, the presenter, which is me. And on the left side of the menu, please select the question and answers icon and type all of your questions there, which will be addressed at the end of the webinar. CMCA credits are automatically generated once the webinar hosting site provides an attendance confirmation report and will be sent via email within 48 hours following the webinar. These credits are non-transferable. Please email education@altitude.law or call Grace directly at 303-991-2076 if you have any questions about receiving your CMCA certificates. Okay. Housekeeping out of the way, let me just reiterate any questions that you have. Please feel free to type them in and I will get to them at the end of the webinar. I think it's easier to answer them that way. So our topic today, the difference between judicial and public trustee foreclosures and why you should care. So big picture, what is a public trustee foreclosure? And importantly, on our next topic about judicial foreclosures, what is it not? So in a public trustee foreclosure, you have a system here in Colorado, which is unique to the United States, which uses a public trustee to actually release deeds of trust and then also to foreclose on deeds of trust. When someone takes out a loan to purchase a property, they'll sign a note saying that they agree that they owe a certain amount of money, and then they also have a deed of trust. And within that deed of trust is a power of sale that allows the lender to sell the property if there's a default. The public trustee here in Colorado, and of course there's a different one for each county, the public trustee's role is to handle foreclosure requests. Since that's what we're talking about today is foreclosures. They handle foreclosures from lenders. The lender will put together a package for the public trustee, send it in, and then the public trustee takes over from that point. Their role is to coordinate every aspect of a public trustee's sale from beginning to end. And they will take all of the paperwork, they do all the publications. Misstate that. They take care of handling the publication of the particular notices. They don't do the publications themselves that actually goes out to a newspaper. Okay? Once all of the notifications have been sent out, the public trustee also then handles the sale. After the property is sold, the public trustee takes care of the redemption process. So we're going to talk a little bit more about redemption in a moment. Okay? And then the bigger question I always get is, well, what's the effect on the HOA lien if a property is sold in foreclosure by the public trustee? The effect is that that lien is extinguished. We can go into more detail in a later slide here. And then there's also overbid funds that you can have from a sale. Now, a bid or the winning bid is going to be over, so there's a little bit of money left over that somebody can claim. So for a public trustee foreclosure sale, a lender generally has to wait until a loan is in default at least 3 months before foreclosing. Lenders also going to be required to send out a notice to an owner 30 days before they actually start before they start the foreclosure process. If the owner does not cure that default, then the lender prepares their documents, sends them over to the public trustee. The public trustee files a notice of an election and demand, referred to as our NED. So anytime we're saying an NED was filed on whatever date it was filed, we're referring to the notice of election and demand that starts that foreclosure process by the public trustee. The public trustee then sets the sale date for 110 to 125 days out in the future, roughly 3 to 4 months. The public trustee then will have the lender's attorney set up a Rule 120 hearing prior to the sale. So sometimes you'll get notices as managers that will tell you you need to object or you can appear at the Rule 120 hearing that's scheduled on X date. The lender has to have that hearing in order to actually sell the property. Now, the thing about that hearing is if the owner has defaulted, has not responded to any notices, and no one files an objection to the foreclosure, the court's usually just going to go ahead and rubber stamp that order, and there will be no hearing. So in contrast, let's talk about a judicial foreclosure and what that is for an HOA. So as I said previously, in a public trustee foreclosure, there is a right to sell the property within the deed of trust. So how does that affect the judicial foreclosure? Because the HOA certainly does not have a deed of trust on the property with the owner. The HOA is able to foreclose based on a statutory lien. So either in the declaration and in Kiowa, you're going to get a lien for any time that there's an assessment that's past due. Okay? We file foreclosures in the district court. So the district court, whatever judge is assigned, is going to be handling our entire case. Everything goes through the district court. Once a judgment is obtained, then you can have the sheriff handle the sale. Whereas in a public trustee foreclosure sale, the public trustee schedules the sale and handles the sale. Once a judgment is entered in a judicial foreclosure, all the paperwork has to be sent to the sheriff. The sheriff coordinates the sale, and they handle that sale. There's also the redemption process in a judicial foreclosure, which is the same as it is in a public trustee. And at the end of the sale, you can also have overbid funds. And if there's not a bid that's received that's sufficient to pay off the HOA, we would consider that an undersale, and the HOA would become the owner of the property unless there is redemption. So I often hear that judicial foreclosures take forever. And my response to that is yes, they do take forever, and they certainly seem to take that amount of time. And if we start a judicial foreclosure and a public trustee foreclosure at the exact same time, the public trustee foreclosure is always going to be completed first, because they don't have to go through the court system in order to get a judgment and then proceed to sale after that. So in our office, our judicial timeline looks like this. So we'll get a request from the client to do a foreclosure, or we'll recommend foreclosure because we can't collect the amount that's due any other way. So we have to order a title report because we want to make sure that we have all of the people or all of the entities that have an interest in this property. So it can take 7 to 10 days to get a title report. We then have to draft a lawsuit. That's a couple days in that process. Have to get that filed with the court. You have to get the person served. Okay? And that's usually where you're going to hear us say that can be a real hang up to try and get somebody served. Because it's one thing for someone who's not hiding, like the bank. You need to serve the lender. And that's great because they're not hiding. However, the owners of the property, some of them have been in foreclosure before or have been served for other reasons, and they know how to avoid service. So sometimes they're avoiding service, and it might take several weeks longer to get them served. And if we cannot get them served, then you're looking to have to publish for service, and publication is another 5 weeks once you get the court's permission to serve them by publication. When you finally do get everyone served, every defendant that's named in the lawsuit has between 21 and 35 days to respond. And the difference for the time period is if you serve someone in state, they have 21 days to respond. If you serve someone out of state or by publication, they have 35 days to respond to the lawsuit. So we're always monitoring those time frames. And then once we have the lender served, you can see I put a little note on there, work with the lender to stipulate to lien priority. Well, what does that mean for you for the HOA? We're going to go and we're going to talk about the super lien in more detail in a moment, but I wanted to put the information out there and say that once we have a lawsuit with the lender involved, we will work with that lender or their attorney to stipulate to lien priority. And that involves drafting a stipulation that says we understand that the HOA's lien is junior to the lender's lien, except for that 6 month worth of assessments, the so-called super lien. So we want to work with them and get this get a stipulation filed with them. So that can take time. It takes longer if they're not represented by counsel. Most of the time they are, but sometimes they're not. And then once we have all the parties served, all the deadlines have passed for them to file a response, we've been able to stipulate with the lender or not, sometimes they also default, we can then ask the court to enter judgment. Judgment can take a day or two to be entered by the court. The court might allow a 21-day period of time to see if anybody responds to our motion for judgment. So sometimes it does take quite a bit of time to actually get the judgment. But from the date of filing, usually 4 to 6 months is when we can anticipate having a judgment and an order and decree of foreclosure. And that allows us to send the package to the sheriff's office, who then will schedule the sale 110 to 125 days out, roughly 3 to 4 months from the date they get the paperwork. So a traditional judicial foreclosure that is not contested by the owners generally takes 7 to 10 months from beginning to end. So as I said it a couple minutes ago, yes, it does seem like forever to get a judgment and get a sale. And again, that's in an uncontested case. If the owner decides to contest it, we have cases that go a year or longer to try to get a judgment and a sale. So what is the super lien? There's a lot of talk about the super lien. People seem to get confused between the super lien, but a super lien in and of itself is 6 months worth of assessments that would have been attributable to the owner before a foreclosure action is filed, whether it is a judicial foreclosure or whether it is a public trustee foreclosure. So in that regard, the amount of the super lien doesn't change. If it's a public trustee foreclosure and you receive notice, which you should as an HOA, you need to contact your attorney, whether it's Altitude or another law firm, and let them know that the lawsuit by the public trustee, excuse me, not the lawsuit, that the foreclosure has been filed by the public trustee. And we can put together a letter that says, okay, this is the amount of the super lien. We expect to receive this at the sale. Same thing happens when it's a judicial foreclosure. You're going to be paid the super lien by the lender so that they not only, try that again, so that they are preserving their own interest in the property. Because the super lien does have priority even over a mortgage, which is why the lender will pay you that 6 month super lien, so that when the property does go to sale, that their lien is 100% superior to the HOA's lien. And it applies whether it is a public trustee foreclosure or it's a judicial foreclosure. It's calculated from the date that either the NED is filed or the date that the judicial foreclosure is filed. And you can have multiple super liens. If the lender decides that they're going to go ahead and file their foreclosure, then you could be entitled, the HOA could be entitled to a super lien once that NED is filed. Usually doesn't happen until after the sale that you get paid, but you would be entitled to it from the date that the NED is filed, or it's calculated from that date. Same if that public trustee sale is then canceled because the owner pays the default amount, but then refiles a year later, the HOA would be entitled to a super lien again. With a judicial foreclosure, we try and take care of the super lien up front because the lender just really wants to be out of the lawsuit. They would prefer to go ahead and pay that super lien. Sometimes it's $150, sometimes it's $1,500 or more, just obviously depends on the amount of the assessments. So they'll want to go ahead and move forward, get the super lien paid and move on with our lawsuit. So before we can actually foreclose, there's several requirements that have to take place. One, in order to foreclose on a statutory lien for the HOA, the balance that the owner owes has to exceed 6 months, equal to or exceed 6 months worth of assessments. So essentially that super lien amount, 6 months. And then the association also has to vote to foreclose on this particular property. It's not sufficient to just say, well, we want to foreclose on anyone that's past due. You would have to vote and say, we want to foreclose on 123 Main Street, Unit B in our association. And then that vote, of course, would have to pass, and the balance would have to meet or exceed 6 months worth of assessments, and then the foreclosure could actually happen. So I'm going to go through the lawsuit process to give you all a better idea of what actually happens when we foreclose. A prior slide talked about, well, we have to get title. Yes, we do. Well, why do we have to get title on the property? And we have to file the lawsuit and we have to serve people. All of that is still true. But what the lawsuit consists of are, of course, the HOA versus whomever. And we get the title report so that we know who the defendants are. The defendants are obviously going to be the owners. They have an ownership interest in the property. The title report will also show us if any taxes are due and if any liens have been filed for taxes. The IRS, any monies that might be due to the county. A lot of times owners don't pay for the sewer, which seems like an odd thing to not pay for, but they might have filed a lien for $100 because the sewer fees haven't been paid. That seems to happen a lot with the city of Littleton, but we would name them the city of Littleton as a defendant. If there's anything else that's owed, any judgment creditors, maybe they owe a credit card company took them to court, and the credit card company received judgment, they would have recorded a transcript of judgment. So we would name that creditor as a defendant in our lawsuit. If there's a deed of trust on the property, and there might be 2, maybe even 3 deeds of trust, we would have to name all of those deed of trust holders as they have an interest in the property. Okay? And again, once we get the lawsuit filed, we get everybody served, we work out any agreements with any lenders. Sometimes we also work out agreements with people that have judgments. They're just not interested in pursuing it. Occasionally it happens with a second mortgage on the property. It may not be worth it to that particular mortgage company to pursue anything, and they know that their lien is going to be extinguished by the foreclosure sale, and they might just either stipulate to a lesser lien priority. They might also file a notice of, a disclaimer in the property, in the lawsuit, saying that they disclaim any interest in the property. So we make sure that we have everybody listed, and everybody is entitled to file an answer, even if they really don't have a claim to the property that's not going to be extinguished. Okay? So again, we stipulate with numerous parties on occasion. Okay? Any party that is served also has the ability to file an answer disputing the foreclosure. Owners will often file answers that say, well, this didn't take care of something that they were supposed to do, so therefore I'm not going to pay for my assessments. I don't have the responsibility to do that. Or they might claim that the association failed to repair a leak, so they're not going to pay it. Essentially, they're looking for any sort of an offset that they can have. Well, under Colorado law, there are no offsets. You pay your assessments, or you can be sued because you didn't pay your assessments. You have a personal obligation, as generally states in the declaration. But we will receive random answers like that, and we'll also receive answers that detail all of the reasons why the person hasn't paid. They've lost their job, they're having marital problems, they've moved out of the property, and none of those are actually legal defenses to not paying your claim. So at that point in time, we might file a motion for summary judgment, just telling the court they have no legal defenses, we're entitled to a judgment of foreclosure, we'd like to move forward with our sale. So it certainly happens. And also when owners file answers, they might just be looking for a payment plan of some sort. By the time an HOA gets to a foreclosure, they're generally not as willing to enter into a payment plan, but occasionally they might be. I mean, after all, these people that are being foreclosed on, they're your neighbors, and the board generally will show some lenience if it's a reasonable request that the owners are making. So, but they can file answers and dispute it, and if an answer is filed, then oftentimes, especially since we're in district court, there are different obligations that the court imposes. Some courts may impose an obligation for mediation, especially if there might be some shred of a legal defense in an answer. We might have to go to mediation. We might have discovery obligations. And all of these requirements by the court end up making the judicial foreclosure take much longer. If we can't get those issues resolved with whomever might have filed an answer, then we might have to actually schedule a trial and go to trial. So the trial itself, especially with COVID right now, I have a trial scheduled for June of next year. You wouldn't think it would take that time to get a trial scheduled, but that's how far out they're moving. So trials just are very lengthy, and there's a lot of discovery that can go into preparation for a trial. It can take weeks to prepare for a trial. We'll have to have all of the documents that prove the claim. We'll need to have witnesses, so we'll have to prepare witnesses. And once that trial date arrives, some of our trials are now being done via webinars, via WebEx platforms, which is a different animal in and of itself to try to present witnesses, testimony, documents. But once we do get through the trial process in a foreclosure, to date, we've not yet had the court not enter an order of foreclosure and allow us to sell the property. So in a nutshell, that is the process that we go through to get to our judgment. So once we do have a judgment, and I can see I'm talking very fast here and I'm getting through this material, so I'm going to have some extra time for questions probably. So once you have a judgment issued, then what do you do with it? Every sheriff, every county has a slightly different process. For example, in Larimer County, they will not have a sheriff's sale scheduled until the association has a bond issued. And the bond is just to protect the sheriff against any irregularities in the process. And Larimer County is the only county in this whole state that requires that. But other counties might require a certified copy of the judgment. All of these things are easy to do. And our office prepares an entire package that goes out to the sheriff. Once the sheriff receives that package, they function in much the same way as the public trustee does. They have an obligation to post notices. They have an obligation to publish notices. They will get those out to the owners and to everybody that has an interest in the property. Part of what we put together is a mailing list, and the sheriff will follow that mailing list and send out copies of all the documents that we've provided to everybody on that mailing list, along with a copy of the statutes. One of the notices that is sent out to the owners is a combined notice for publication. That title may not mean anything to you, but you may get one in the mail for a notice, because the public trustee is also required to send out the same type of notice. But that notice is essentially telling the owners that there is a foreclosure sale that is scheduled. It's scheduled on, let's just say, September 1st of 2020, which we would have passed that date. But you have 15 days prior to the sale to ask for a cure statement. A cure statement is simply telling the owner how much they owe. For a public trustee sale, the cure statement will look like a default notice. This is what it will take to cure your default. Because the lender's not asking for the balance in full. Maybe the owner is, by that time, 8 months in arrears. So they're going to be asking for those 8 months, and that will be their cure statement. For the HOA, for the sheriff's sale, when we provide a cure statement to the sheriff for the owner, it's going to be 100% of the balance that is owed to the association. And if the owner properly requests that cure statement 15 days prior to the sale, then the sheriff will get that notice to us. We'll provide the cure statement back to the sheriff, who will provide it to the owner. At that point in time, the owner is supposed to be dealing with the sheriff. I don't know how many managers have received these phone calls from us the day before the sale. The owner has reached out to us and would like to pay this in full. May we reschedule the sale for a week while we get a balance to them and give them all the information and get payment? So that frequently happens with the sheriff's sale. The owner completely ignores the notice and just reaches out to our office. And as long as they do that prior to the sale, we're fine with that. We'll give them the total balance due. Okay. So once all of the paperwork has been sent out to the sheriff, everything has been published, we have a sale date. 2 days prior to the sale, the sheriff is going to ask us for our bid. So the bid is going to be calculated based on everything that is owed to the association. There'll be a publication fee for the sheriff, the amount of the judgment, any assessments that have accrued since the date of the judgment, any interest that's accrued on the judgment, late fees, anything that's on the ledger, as well as all attorney's fees and costs up to the date of the sale. I'm just going to use a round number because it's easier. So let's just say our bid is for $25,000. That bid gets submitted to the sheriff, and 2 days prior to the sale. And on the date of the sale, the sheriff will just simply advise anybody that shows up at the sale which sale they're conducting, will provide the amount of our bid, which again, $25,000. And if someone bids $25,001, and that is the only bid received at the sale, that person will receive a certificate of purchase from that sale. Is that the end of it? It is not the end of it. When you receive a certificate of purchase, the HOA does get paid in full, which is a great part for the HOA. They will be paid in full because we received the entire bid. If there are no bids on the property, then the HOA is actually going to receive the title to the property unless someone redeems. So here's all my information on redemption. If it is a public trustee foreclosure sale, then any junior lien holder can redeem. They have a right to redeem. And managers, I'm sure that you get calls from us and from other investors saying, we want to buy your lien. That's because they want to have a junior lien position that allows them to redeem at a sale. They don't have to participate in the bid process because they have a junior lien. And so they're able to just participate in the redemption process. The same goes for the sheriff's sale. As long as you have a junior lien, you can redeem from whoever originally purchased the property. And if there were no bids, the redemption process still has to happen. So anybody who has a junior lien is able to redeem the property. The redemption process is that whoever has the junior lien files an intent to redeem. That intent has to be filed within 8 days following the sale. And then that lien holder would pay the amount of the bid to the sheriff. And the original purchaser gets their money back, along with a little bit of interest and some nominal fees. And then that junior lien holder actually becomes the owner of the property. Now, if there are multiple junior lien holders, the most senior junior lien gets first crack at the property, and then the most junior lien holder is able to have the last crack at the property. And if there's only one junior lien holder that redeems, they end up receiving the title to the property. So I have the question a lot, how does a sale affect the deed of trust? A lot of boards become concerned that when the property sells, they are going to be responsible for paying that deed of trust that the owner has with their lender. And the deed of trust gets paid by either the owner of the property because it's their financial obligation, or whomever purchases the property at the sale purchases the property subject to that deed of trust. So if, let's just say, an investor purchases the property, which is what normally happens, they purchase the property subject to that deed of trust. If they want to then sell that property with clear title or prevent the lender from foreclosing on them, they will have to pay off the lender. It is not the HOA's obligation to pay the lender. It's not their debt. Now, if the HOA ends up receiving title to the property, the HOA has a couple of options. They can keep the property if their document allows them to purchase property. They can pay off the first deed of trust and own that property as an association. Okay? And then they can rent it out if they'd like to do that. But without having to actually purchase the property, they can also rent the property until the lender decides to foreclose, which if the original owner of the property no longer owns the property, the chances that they're going to continue to pay the mortgage are very low, and eventually that lender will go ahead and foreclose. So the association might have several months to rent out the property, or they might have a year or more to rent it out before the lender forecloses. So they could recoup some of their money that way. The HOA also has the option of just selling the property outright. They own it because they received a sheriff's deed to the property from the sale. So they can sell it just as if you or I own the property. They just list it with a realtor and sell it. And in that case, the first deed of trust will have to be paid. Anyone who had a lien on the property beyond that first deed of trust, their lien will be extinguished by the sale. It's the same whether it's a sheriff's sale or it's a public trustee sale. once that property is sold, all junior liens are extinguished. The nice thing about the redemption process, specifically with regard to a public trustee sale, is that the HOA has the ability to file an intent to redeem without actually having to purchase the property if there are overbid funds. So let's say the association is owed $3,000 or $4,000, and instead of having their lien extinguished, there's $10,000 sitting in trust from overbid funds. Our law firm, or whichever attorney you may use, can go ahead and file an intent to redeem on behalf of the HOA and get those overbid funds and get you paid. And you don't have to pay for the property, nor would you become the owner of the property. Keeps your lien is still extinguished, but you at least get money out of it. So that's basically foreclosures in a nutshell. And again, I talked a little bit fast today, so I apologize that it's not taking your entire hour. See if there's anything else I want to go over with you. So I think one of the biggest differences in HOA foreclosures when they go through the judicial foreclosure process and public trustee foreclosures is just how it affects the HOA's lien. Because as I said earlier, the HOA's lien becomes extinguished in a public trustee foreclosure sale, where as in the sheriff's sale, you get paid, hopefully. In about 95% of cases, you will get your money in an HOA foreclosure case. About 5%, you're going to end up being the owner of the property, and you'll be able to resell the property. Sometimes, unfortunately, there's a crossover between a public trustee sale and a sheriff's sale, and whoever gets first is going to be the one that gets to sell the property. If the public trustee sale happens first, then the judicial foreclosure process is essentially stopped. In fact, if there is a crossover, we'll advise our clients to let's wait and see. If we think we can beat them, we will. And that's always a challenge in knowing how much time you're going to need to get your own judgment, and can we proceed to sale on a judicial foreclosure and beat out the public trustee foreclosure. Because it's interesting to me that the lender doesn't really seem to care who forecloses. They're not being paid. They know if the HOA forecloses, they're still going to get their money out of the sale because their lien doesn't get extinguished. Whereas if their sale happens first, the HOA's lien gets extinguished. So it's always in the association's best interest if they can get to sale first. Okay. I see a couple questions up here. Excuse me. So one of the questions was, can you get a copy of the presentation? If Grace didn't already send it to you, please let me know who's asking, because it's an anonymous question. We'll go ahead and make sure you get a copy of it. But absolutely, and if you would actually like to email me afterwards, you can do that too. You don't have to do it through our presentation. My email address is now up on the screen. And then the other question is, how have COVID-related mandates affected the process or timelines? So because this presentation is not designed to cover that question for COVID-related foreclosures, I'm going to ask that you contact me outside of the webinar. And if you have questions I can answer, I will certainly do that. But in general, I'm going to try to answer your question. I've actually attended webinars that talk about this specific topic. But in general, HOA foreclosures were not affected by the mandates that said you can't foreclose on certain properties. And the federal moratoriums that were put in place only related to certain FHA HUD-backed mortgages, and that's probably not the right word I'm looking for there, but you had to be a very specific mortgage on a specific type of property, mainly single-family homes. So a lot of times those moratoriums were not in place for most foreclosures. It's just, I think lenders have taken the approach that unless they absolutely have to move forward with the foreclosure, they're not going to do it. You know, I hope that answers that question. But again, please feel free to contact me offline. All right. A little bit short. Okay. So the question is, and I should have put on my reading glasses for this. So what are the major differences between a foreclosure and a deed in lieu of foreclosure? So if whether it be a lender's deed of trust that's being foreclosed or an HOA lien that's being foreclosed, an owner can offer you a deed in lieu of foreclosure. Does not happen that often in HOA foreclosures. I think I know of one case where it happened, but in a lender foreclosure, instead of having to go through the entire foreclosure process, the owner of the property can simply say to the lender, I'm just going to sign this over to you. There's no need to go through the foreclosure. You can have it. I don't have the money to pay you, and I'm upside down anyway. With the market here in Colorado, there have been rare occasions that the person is going to be upside down. I mean, maybe they borrowed an excessive amount of money on their property, have 2 or 3 mortgages, and the property is tanked. Then maybe a deed in lieu would be the answer for an owner. But in most cases, the property is going to be worth more than you own on it. So you just don't see that often. I hope that answered your question. Anything else? Anything else I can answer for anybody? All right. Well, again, I do apologize for being shorter than I anticipated. So please feel free again to contact me offline, and I'll be happy to answer any other questions for you. All right. Thank you for attending today.